Hello, everyone. I'm Major Garrett in Washington. Let me welcome you to The Takeout. We begin with James Madison and a point he made in the summer of 1787 during debate over the American Constitution. Why? Because it is relevant to events in Portland this weekend and Chicago today. Quote, "A standing military force with an overgrown executive will not long be safe companions to liberty. The means of defense against foreign danger have been always the instruments of tyranny at home," unquote. Federal District Judge Karen Immergut included that observation in the granting of a temporary restraining order against President Trump's attempt to federalize Oregon National Guard forces and send them to Portland. Judge Immergut ruled President Trump's justifications were, quote, untethered to the facts. The facts, the judge ruled, showed existing federal officers with local police can and have protected federal buildings in Portland, that summer protests had died down, that the threat of violence in Portland was manageable. But something deeper was at issue in Portland and other jurisdictions where the Guard might be federalized. Judge Immergut wrote that if the administration's sweeping definition of threats of future rebellion or stresses on existing federal resources were accepted, quote, then the president could send military troops virtually anywhere at any time, unquote. The gravity of that possibility led Judge Immergut to conclude as follows, and I quote, "This country has a long-standing and foundational tradition of resistance to government overreach, especially in the form of military intrusion into civil affairs. This historical tradition boils down to a simple proposition. This is a nation of constitutional law, not martial law," unquote. President Trump, we should remind ourselves, appointed Judge Immergut to the federal bench. Early in her law career, Immergut was part of Special Counsel Ken Starr's investigation of President Bill Clinton, a kind of calling card of credentials for young lawyers in conservative circles back then. We should also note that Judge Immergut also today, or not today precisely, but right now, lectures at Stanford University. Trump not only criticized her ruling, but sought to sidestep it by sending federalized National Guard troops from California to Oregon, prompting a hearing late yesterday where Judge Immergut, before blocking that move, incredulously asked of the Trump administration, quote, "Is there any legal authority for what you are doing?" That question hangs heavily over Portland and Chicago, where leaders there sued to block the deployment of Illinois National Guard troops or the deployment of National Guard troops from other states. We begin tonight with Ash-har Quraishi, who is covering the latest developments from, I'm checking my notes, Broadview, which is a Chicago suburb. Ash-har, what's going on?
Well, as you mentioned, simply put, Illinois and Chicago argue that the federal government is overstepping its authority, calling the planned National Guard deployment unconstitutional and politically motivated. The lawsuit claims the president cannot use the military to occupy American cities simply because local leaders disagree with him. The filing cites states' rights, the Posse Comitatus Act, for example, and the risk of escalating violence and not restoring order, Major.
And what is the state of play in and around Chicago right now?
Well, there's a mix of anxiety here. There's also some defiance. We've been talking to a lot of folks here, but city officials have been saying for days they've been urging calm, but preparing for the possibility that these troops could potentially arrive. In the meantime, protesters have been periodically rallying. Behind me, we're starting to see some people showing up here outside that ICE facility in Broadway. And Chicago police and other police in the area have been told to coordinate only as needed to respond to specific incidents, but not to assist in any of the arrests that are going on around these areas. And they're warning that a show of force, like more troops here in the area, could potentially turn these protests into outright confrontations, Major.
And very quickly, Usher, you're not seeing anything that constitutes widespread violence or protests that could escalate to something violent?
No, we've seen for the last 3 weeks or so, Friday nights, Saturday nights, protesters gathering here in Broadview in particular. And there have been escalations. We have seen some dozens of arrests over the last weekend or so, but they haven't been large scale. Again, this is a very small area behind me, maybe less than a city block. So it only fits a certain amount of people. But one of the developments that we've seen today is that the Broadview mayor actually has put a restriction on the hours in which protesters can come out here. That is now restricted to between 9 a.m. and 6 p.m. So we may not see those kinds of confrontations we've seen in the later hours over these weekends. Major?
That's an important local development. Thank you so much for bringing our attention to that. Ash-har Quraishi, thank you so much. I appreciate it. CBS News legal contributor Jessica Levinson is here with me now. Jessica, it was a very busy weekend, filings back and forth. As I outlined, Judge Immergut got involved in this case, reviewed the facts, reviewed the existing law, reviewed the case filing and everything that happened in the Ninth Circuit with the federalization and deployment of forces in California around Los Angeles. Summarize the key points for our audience.
I think you did a great job of outlining this. So step number one was the first temporary restraining order that Judge Immergut issued. And this was in the face of a challenge from Oregon and Portland, where they said that the president, under this federal statute he's been pointing to, Section 12406, just doesn't have the authority to federalize the National Guard. Judge Immergut agreed, and she distinguished what was happening on the ground in Portland from what happened from where I'm speaking to you from, Los Angeles. That's in part because she had to, because the Ninth Circuit had essentially blessed the Trump administration's desire to federalize the National Guard as a result of protests in Los Angeles. She said what's happening in Portland is very different from what happened in Los Angeles. And so she said, while presidents get a lot of discretion to make this call under 12406, presidents get a lot of discretion to say, I'm unable to execute federal law through the regular forces, which is part of what the statute calls for. She says that's not unfettered discretion. So that's TRO number one, Major. Then what happens as a result is that the Trump administration says, okay, well, we have these federalized National Guard members in California. We'll just send them up to Oregon. That's where we get that late night emergency hearing last night. Judge Immergut sounded very frustrated with the Trump administration. And she said, you can't do this. You can't circumvent my TRO because I just told you the facts on the ground in Oregon don't allow you to federalize the National Guard. Don't now try and take members of the National Guard from other states to get around what I just told you. So that's what's happening in Oregon. And as we know, there's suits in other jurisdictions as well, all asking that same question. When does the president have the power under the statute to federalize the National Guard over the wishes of governors and other elected officials?
Because as the opinion, as I read it, Jessica, made clear, the judge said, look, you can have facts. You can have facts that are in dispute, but you cannot invent facts that don't exist, point one. Point two, you cannot use a bizarre or invented definition of something like rebellion, because the judge said the terminology that the president is using, rebellion, to define doesn't fit with either a classical definition from when the laws were written a long time ago or our commonly accepted definition now.
That's exactly right. So what I saw the judge doing is saying judicial review, number one, is possible. So she's obviously taking a look at this. The Trump administration had previously argued that judges couldn't review these decisions at all. Number two, she's saying, I understand that, as I'm of course paraphrasing here, but as an unelected judge, I don't get to substitute my judgment for the judgment of the elected chief executive. But then number three, as you point out, what she's saying is she can still look. And so while there's a lot of discretion here, what she's saying is there's nothing on the ground that indicates that those factual predicates are present that would allow the president to take this power to call into federal service the National Guard.
Jessica Levinson, always brilliant, always on point. Thank you so very much for your time.